This show is sponsored in part by St. Germain Catering, a woman-owned business that is professional in every delicious detail. And Fairfax Social Sports, Northern Virginia's largest co-ed men's and women's adult sports league, with over 32,000 players who participate in flag football, softball, basketball, and other adult sports. And finally, the Ruddy Law Firm in Fairfax City, Virginia, a law firm that provides legal services in the fields of business, probate, estate planning, and elder law. Welcome to the Probate Nation. My name is Richard Ruddy, and I'm the moderator of a show entitled How to Probate an Estate in Virginia. Probate is a process to transfer ownership of probate assets to the beneficiaries of a deceased person. Like a journey on a slow-moving steam engine train, probate has a beginning, several stops along the way, and at the end of the trip, the balance of the probate assets are delivered to the decedent's beneficiaries. Some probate train rides are short, while other probate rides seem to never end. In an earlier program, we discussed how to initiate probate and start your probate train on its journey. What we learned are two important points. First, you will need to be properly qualified at the local probate office in order to probate an estate. And second, in order to get qualified, you must be bonded. Many people scratch their heads and ask, what is this bond the executor must give and why is it necessary? In an earlier program, we asked Fairfax Commissioner of Accounts, Jack Russ, this question, and here's what he had to say.
Unfortunately, we see from time to time there are occasions when fiduciaries violate the trust the court has placed in them. They may make a mistake in distribution where somebody doesn't get what they're supposed to receive. They may abscond with the funds of the estate. It does happen. And in either case, the people who are entitled to the money are going to get hurt. The fiduciary has a bond that is intended to protect against such injury. It's a promise from the fiduciary to fulfill his fiduciary duty. It's the basis for seeking personal recourse, that's a judgment, against the fiduciary. Now, there are really two types of bonds. The first is a personal bond, and the second is a bond with corporate surety. The fiduciary bond, the one that the executor or administrator signs, is personal. The fiduciary is the only one who is responsible if there's an error in the administration. If the fiduciary doesn't have any assets, if the fiduciary is gone and you can't find him, the creditors and heirs of the estate are going to get hurt. The bond's not going to do them much good if it's only a personal bond. A surety bond it basically requires an insurance company to stand behind the pledge of the fiduciary. And in the event there's a problem, the bonding company will come forward, make the creditor whole, make the beneficiaries whole, and then pursue recourse against the recovery against the fiduciary. It's an important protection for those who are interested in the estate, and it should not be lightly waived.
There are two types of bonds that you could be asked to give at the time of qualification. And as Mr. Russ notes, giving a personal bond, one with no surety, is relatively easy to provide. Typically, this occurs where the decedent waived the need for surety in his will. On the other hand, obtaining a corporate surety bond is more complicated and certainly not guaranteed. Remember, if you must be bonded with surety and you cannot obtain that corporate surety bond, then you will not be allowed to qualify to probate the estate. So, how do you apply for a corporate surety bond? When should you apply? And what factors are considered by the insurance company in deciding whether to issue a surety bond to insure you or not? These are all questions that we want to answer today. And to answer these questions, we have invited three local fiduciary bond agents who serve the Northern Virginia probate offices and process applications for corporate surety bonds to visit with us. Keith Siegfried is president of Moore Clemens & Company, Loudoun County's oldest insurance agency located in Leesburg. He is a Virginia Tech graduate who has been an independent insurance and bond agent for over 30 years. Over the years, he has earned the industry designations of Certified Insurance Counselor and the Chartered Property Casualty Underwriter. Presently, he serves as the Education Committee for the Professional Insurance Agent Association of Virginia, NDC. Sue Wilkinson is from the Grimes Agency in Fairfax, where she has been writing fiduciary bonds for executors on behalf of Grimes for over 10 years. Governor Burke is the president of Julian T. Burke, Inc., a family-owned insurance agency located in Alexandria that was started by his grandfather in 1932. The agency has handled fiduciary bonds for many years. Governor especially enjoys guiding clients through the bonding process, which can be unfamiliar and challenging to first-time executors and administrators. Please welcome Keith Siegfried, Sue Wilkinson, and Governor Burke. You know, Keith, in discussing corporate surety bonds, it has to begin with an understanding of exactly what is a corporate surety bond. Can you explain what that is for the folks?
Sure, Richard. It differs from an insurance policy, which most of your viewers are familiar with. An insurance policy is a two-party contract between the insurance company and the policy holder. The policy holder pays a premium in return for the insurance company's promise to pay if an event occurs. A bond, on the other hand, is a three-party transaction where it involves the policy holder, which is the principal, also known as the fiduciary. They apply for the bond with corporate surety. The surety, in turn, guarantees a maximum sum to the obligee. And in your case with probate, the obligee is the court. And the court will oversee the bond and the estate.
Okay. Now, I just on our screen, we're going to show folks the actual application process. We turn to the next segment of the show about how you actually apply to obtain a corporate surety bond. Governor, can you talk a little bit about how one goes about to actually apply for a corporate surety bond?
Sure, Richard. The client, who's the executor or the administrator of the estate, would call an insurance agent who handles bonds, such as the three of us, and have a little interview over the phone with the bonding agent, giving particular personal financial information and also occupation, address, things like that. And then the insurance company would run a credit check and do background check on the potential client to see if they would qualify for their underwriting guidelines.
Okay, very good. Now, Sue, what are some of the factors that are important in the process of evaluating whether or not an insurance company is going to actually issue a surety bond?
Sure, Richard. Very important is the fiduciary or the principal has a solid credit score. That is very important. Also, typically on most of the bonds, they need an attorney, a qualified probate attorney, to help them out and guide them through the process. The principal also needs to have an occupation. That's very important in the eyes of our underwriters, that they have an income coming in. It does help if they are a CPA or have some type of knowledge as far as money or handling money,
Okay.
To get approved for a bond.
And the importance of having a job is because
That there is an income that they not only know how to handle money, but they don't have to worry about somebody who may not have a job or may have lost their job. It might be more tempting for them to get their hands on the money in the estate, whereas if you have a solid job and you have an income, there's no worries with that, or very little.
Okay, very good. Keith, what are some of the factors that come into play as to why a bond is denied?
Richard, probably the biggest thing that would deny an applicant for a bond is their credit history. The underwriters pull a score, a credit score, and normally will give us thumbs up or thumbs down. In addition to the credit is the capacity. Does someone have the financial net worth to pay the bonding company back if there is a claim? So they will look at personal assets. And then the last piece of the puzzle for an underwriter is, do they have the character, which we call the 3 C's, credit, capacity, and character. And with the character, do they have upstanding moral and ethical character in their profession as well as in their community?
Okay, Very good. So we're now going to move to the process by which we actually obtain the bond in connection with going ahead to get qualified to probate. So in some of the jurisdictions, the probate offices require you to get pre-approved if in fact you need to have a corporate surety bond. Others will allow you to actually just show up and start through the process and make your application while you're there. So I'm going to start with you, Governor, because I know you work extensively in Alexandria and Arlington. Tell us how the process works in those jurisdictions.
The process is fairly similar between those two jurisdictions. You're going to go into the clerk's office, and you're going to spend about an hour with the clerk, in which during the course of that time, you're going to sign the bond. The insurance agent normally would be there to sign the bond on your behalf. The amount of the bond is going to be a little bit different in the two jurisdictions. In Arlington, typically they set the bond 5% above the value of the probate estate, whereas in Alexandria, you can set it for the minimum amount at the value of the estate, but you can go up from there if you like. It's your option.
And in the intake process at the probate office, they would identify before they make the appointment if a bond is necessary, and then sort of get you guys working on that before they show up?
Most executors are going to be told whether or not they have to have a bond based on what's in the will and based on state laws.
Sure.
Executors, if the will says that they're waived from having a bond, that's great, unless they happen to live out of state. If you're out of state, you're going to have to be bonded anyway.
Okay.
And administrators who qualify like an executor but without the benefit of the will, in most instances, they will have to be bonded. There are a few exceptions, however.
Okay. Sue, in Fairfax, and in Prince William, how do they coordinate the qualification process, that meeting with the probate office, and getting bonded?
Sure. Fairfax and Prince William are very different from one another. In Prince William, you need to get that bond approved prior to even making a probate appointment with the clerk. So you need to get that set up. And their bond is set at approximately 10% over the estimated value of the estate. As far as Fairfax goes, ideally it is best to get the bond approved before you go to your appointment, but also they can accommodate the fiduciaries, or we can accommodate them, that during the appointment we can go through that approval process and hopefully get them set up for their bond while they're there during their appointment.
Okay.
And their bond will be set a little bit differently. It's 1/3 over the value of the estate for Fairfax.
Okay. And Keith, how about out in Loudoun County? How do they do things out there?
Yes, sir. Excuse me. Loudoun will meet with an administrator of an estate and get some preliminary information, but they will not qualify the administrator until such time that they have prior approval from a bonding company, corporate surety. And normally, at the time of qualification, they will establish the bond amount, rounded off to the nearest 1,000 or 5,000.
Okay. Well, the whole process by which the bonds are obtained and some of the criteria that are required to be met, or things that will actually cause you not to get a bond, are very challenging, I think. But you guys have seen how these bonds play out in real life, so I want to get some closing comments from each of you about some of the things that you would say to people who are qualifying, things that they should do and they should not do. So I'm going to start with you, Governor. Can you share some thoughts?
Sure. I think one of the main things, Richard, is that people file their paperwork in a timely manner to be consistent with what the Commissioner of Accounts, who's overseeing their activities, is expecting. That'd be the main thing. The other point, I think, is if you have a question or a concern, don't charge ahead blindly. Get help from a professional, whether it be from your attorney or your CPA, to know what you need to do, rather than having to apologize after the fact for making an error, which may cause you to get into a lot of trouble with the court.
Okay. And Sue, how about yourself? Your comments?
Yeah, I echo what Governor said. I think it's, at that time, going through the probate process can be very overwhelming for these people, and I understand that there's a lot of information given out. So retaining or even just consulting with a qualified probate attorney can be very, very beneficial. when going through the process.
I agree. And Keith, how about yourself? What are your observations?
Stay in constant communication with the Commissioner of Accounts, Richard. Ask questions, and then ask questions of your professional and your bonding agent. We're here to help you.
Of course, of course. Well, I want to thank you folks for doing just a great job of explaining the bonding process and how things play out, and giving the advice, the practical advice to folks about things that they should do to make sure they don't get in trouble with their local Commissioner of Accounts or the probate office. We're going to take a brief break, and when we come back, we're going to talk with one of the attorneys who actually enforces those bonds when, in fact, you do step outside the lines. To this point, we have been discussing how to obtain a corporate surety bond. But let's turn to a more serious topic. We have a bond, either a personal bond or a corporate surety bond, to ensure that the executor performs. But it turns out the executor fails to do the job correctly. Now what happens? There is a process to ask the Commissioner of Accounts to forfeit the personal bond of the executor. And if successful, that will end up in a personal judgment against the executor. On the other hand, the corporate surety bond process is a little more complicated, and we're pleased to have a local attorney here who represents the bond companies that underwrites those surety bonds to discuss this topic. He is a lawyer in private practice in Tysons Corner, Virginia, graduated from Georgetown Law School, where he now serves as an adjunct professor. He has represented surety companies for over 15 years and has extensive experience working with the Fairfax County Commissioner of Accounts Office on fiduciary bond claims. Please welcome Chris Anzaday. Welcome, Chris.
Thank you, Richard. Thank you for having me.
You bet. We've been discussing the application process, about how you obtain a corporate surety bond, but and there is this very, very detailed indemnity agreement that gets signed as part of that application process. And we showed that on our screen earlier, but that goes on for some length. And of course, you're called upon that to enforce that from time to time. When do you normally get involved with estates that have gone bad?
That's right. Well, normally the surety company will not be involved in the day-to-day administration of the estate. The surety company in a lot of ways is like the principal of a high school. They're happy to not know you. They're happy to know that you're staying out of trouble, doing what you're supposed to do, not getting any bad reports. On the other hand, if something goes wrong, you find yourself having made an error that's not corrected, non-responsive, then the Commissioner of Accounts is going to send a notice to the surety company and bring the surety company into the administration, and that's probably going to take, that notice is probably going to take one of three forms. A show cause notice, or perhaps in conjunction with that or on its own, a petition to remove the fiduciary and actually have them replaced. And then the third and most serious that we'll talk about is actually a petition to forfeit the bond itself and hold the surety company liable. So typically when the Commissioner of Accounts has an issue that's brought to their attention that they feel they need to bring to the surety company's attention, at that point the surety will bring in counsel to assist them with the estate.
Okay. So you mentioned the show cause notice. What is that?
Yeah. Think of the show cause notice as something of a wake-up call. The Commissioner of Accounts, it could vary depending on the jurisdiction, but the Commissioner of Accounts will typically start with a show cause notice, giving the fiduciary an opportunity to correct an error or perhaps correct a failure to timely file an accounting. Usually, again, things that can be fixed, things that can be remedied, not making an accounting in the time you were supposed to, not providing documentation, or perhaps other errors that are fixable. So the show cause notice is an opportunity for the fiduciary to correct a problem with the administration of the estate.
So when I, as a fiduciary, get a show cause notice from the local commissioner, what should I do?
You should, first of all, pay attention to it. Read it. Make sure you understand what the concern is. If you have questions, I think we heard in the prior segment, go to the Commissioner of Accounts and set up a meeting. Talk about it with them. Get a professional involved. If you don't have an attorney assisting you or an accountant assisting you, perhaps that's a good time to engage the help of a professional.
Okay. So let's just say that the show cause notice does not wake up the fiduciary.
Yeah.
What's the next step that takes place?
Yeah, well, very often you'll see the commissioner move on to a petition to remove the fiduciary, have them replaced, and have a successor fiduciary named, usually an independent accountant or lawyer who has no prior interest or involvement in the estate, to come in and take over the administration of the estate. And then along with that, you may see a petition to forfeit the bond itself. That would occur in a circumstance where there is money missing, either through an error or sometimes we see just through an intentional taking of the money by the fiduciary. Typically, though, it's just as a result of an error, through a mistake, money is now missing and has to be put back into the estate. And that's when, in conjunction with removing the fiduciary, the commissioner would look at forfeiting the bond.
Okay. And again, if I, as the fiduciary, was to receive that petition by the commissioner, your recommendation about what I should do as the fiduciary?
Yeah, that's particularly if there's a petition to remove the fiduciary, or if there's any indication that the commissioner may be seeking to forfeit the bond. That is a very serious concern, and you should, number one, immediately make sure you make an appointment and speak with the Commissioner of Accounts and understand what their concerns are. Number two, I would recommend engaging professionals if you don't have a lawyer or an accountant already. Getting in touch with one. The Commissioner of Accounts often has referrals and things that they can make, but getting the help of a professional so that if there are problems with the estate that can be fixed, so that you go ahead and get them fixed.
So what happens if there actually is ultimately a bond forfeiture? What happens next?
Sure. A bond forfeiture would be a circumstance where then the surety company would be called upon to pay back some or all of the amount of the bond, just depending upon what findings are made by the commissioner and the court as to how much money needs to be put back into the estate to make the estate whole. At that point, the fiduciary is not off the hook, and sometimes we see that the fiduciaries don't quite understand. They think that the bond is an insurance product. It's there to repay, or if there's a problem with the estate. Well, that's true, but where it differs from insurance is that the bond is there to protect the estate and the assets of the estate. The fiduciary is still responsible and still liable, and so what the surety company will do is they will come in and repay the estate and actually get a personal judgment against the fiduciary who was in charge or responsible for the estate at the time the loss occurred. So if you're removed and if there's a petition to forfeit your bond, don't expect the surety company to go away. They're going to pursue legal action against you, the fiduciary, to obtain repayment for any amounts that they have to repay into the estate. And in addition, the surety company will typically seek a judgment for their legal fees and expenses and other court costs and things. So it can be a very, very expensive proposition. And many of these errors, let's stress again, that result in a bond forfeiture can be corrected. Many of them have to do with just paperwork that's not provided, documentation that's not maintained, records, contemporaneous records that are not maintained, and a lack of proof to be able to satisfy the inquiries of the Commissioner of Accounts.
We're going to talk with one of the auditors at the Commissioner's office about the type of proof they'd like to see. But in part of the application for the bond that you submit with the bonding companies, who we talked with earlier in this program, the application includes a very extensive indemnity agreement at the bottom of page 1 and going on to page 2. Is that what you then use in order to obtain the personal judgment?
That's right. There's actually two mechanisms. One is found in the indemnity agreement itself, and you should read and understand those obligations. You should also understand that it's not the type of agreement that can be negotiated. You heard that, unfortunately, you heard that in the first segment that one of the factors that's considered in the underwriting process is your credit. And the surety is really, the purpose of the surety is to enhance the credit of the fiduciary so that these agencies and the Commissioner of Accounts will want to issue a bond. And so the terms really aren't negotiable at all, but you should pay attention to them and read and understand your obligations, and try to comply with them as best you can, because that is one of the tools that the surety company will use to obtain repayment if the surety is called upon to pay under their bond. Even aside from the indemnity agreement, Virginia, by statute, provides that a surety will obtain a judgment against its fiduciary for any amounts it has to repay into the estate, plus a 5% penalty by statute if the surety is called upon to pay on the bond. So you've got the indemnity agreement, number one, and number two, even without the indemnity agreement, the surety has a statutory protection. So it's very, very important, particularly if the Commissioner of Accounts has given a notice to the surety company, that you do your best to respond and rectify any problems with the estate.
And these judgments are not dischargeable in bankruptcy, I would imagine.
It depends on the circumstances, but they may not be. And so typically a fiduciary would not want to go through that process anyway. No, it's not really a comfortable process going through the bankruptcy, and it would be an open question as to whether that judgment would be discharged in bankruptcy.
Okay. Well, based on some final thoughts from you, based on your experience as counsel to the bond companies, what are some of the things that you've noticed would recommend to fiduciaries that they should definitely do in order to stay out of trouble with the Commissioner's office and get involved in the whole bond forfeiture process?
Yeah, I mean, many of the problems that I see are very much fixable if steps are taken by the fiduciary to be proactive in discharging their obligations. What does that mean? That means filing your accounting on time, keeping your paperwork organized so that if the Commissioner of Accounts does have questions, you can go back and answer those questions readily, and we're not dealing with a circumstance where a few years later you're trying to piece together what happened. So being proactive and being organized and hitting all your deadlines is extremely important. And if the Commissioner raises questions, I think getting the help of a professional, a lawyer, an accountant, somebody who can assist you in responding to the Commissioner's questions, I think is very, very important. And I very much recommend when I speak with a fiduciary after getting a notice, I typically recommend, if they haven't retained counsel, that they should.
Okay. Well, Chris, I want to thank you for your valuable insights on the enforcement process, and certainly, hoping to give some suggestions about things that the fiduciary should do along the way to make sure they don't get introduced to you in the process of their estate administration.
Thank you for having me.
You're very welcome. I want to thank again our guest, fiduciary bonds person, Keith Siegfried, from Moore, Clemens and Company in Loudoun County, Sue Wilkinson from Grimes Insurance in Fairfax, and Governor Burke from Julian T. Burke in Alexandria, as well as attorney Chris Anzadeh of Vienna, for taking the time to talk with us today. We hope you found the information on bonding the executor provided by our guests helpful. Serving as an executor is a serious responsibility. Being bonded, whether with corporate surety or with no surety, imposes personal liability exposure on all executors who serve. If there's one message I draw from the discussion today, it is that every executor should get advice early in the probate process from an experienced probate attorney and allow them to guide you on your probate journey. It is so easy to make an unintentional mistake, and yet often easier to avoid that mistake with an experienced attorney guiding you. And should you make a mistake that triggers enforcement action against you, you should immediately get counsel involved to help you solve the problem so your probate journey is not delayed. This brings us to the conclusion of our show today on bonding the executor. At this point, you are bonded, qualified to administer the probate, and in the midst of marshaling the estate assets and identifying its debts. Good luck as your probate journey continues. On behalf of myself and the entire Probate Nation, thank you for visiting with us.